Hello everyone, welcome back to the audit and attestation class. So in this class, we'll be understanding in detail about the Security Exchange Act 1933. So let's dive into for more detail.
Next section we have, important section we have in Security Act 1933 is section 11A. Security Act 1933. Section 11A regulate the public offering of security. So this section 11A is very much important in Security Act 1933. It shares all the information to regulate the securities for the IPO, and it requires the companies to file the registration statement with the SEC prior to sale of any security. So the entity cannot sell the security to the general public or public at large unless and until they file the registration statement. In the registration statement, they will be filing all these details which we have discussed above: the description of the company, description of the company property, business, security offering, management, audited financial statement, and other relevant information. Right. So section 11 require an entity to comply with the requirement of the Security Act 1933. Third is right of a person who acquired security. So the person, when you are issuing like IPO and like some general public has acquired the share in the IPO. So what all rights that individual or you can say investor do have, right? If, for example, the financial statement on which that investor has relied has certain misleading or fraud information, so then that investor has a right. Section 11A give the right to the investor to sue to the CPA who has signed the financial statement. Right? If the financial statement attached with the registration form is being signed by the CPA and investor has relied on those financial statement which is being signed by the CPA, and if there is any misleading, fraud or error or wrong information in that financial statement, then investor can sue directly to the CPA who has signed the financial statement. This right comes under section 11A for the investor. Right? Makes sense? Any doubt here?
But then automatically the appointed CPA would be, down from his duties once the
Sorry, say that again, Kashish.
Sir, like you said now, if there is a fraud in
yes,
financial
like for
statement,
example,
or is there
Kashish,
any misleading?
for example, let's say Kashish is a CPA and let's say Garvit has a company who is going for IPO. Right? So Garvit came to Kashish to sign the financial statement, do the audit and sign the financial statement for the IPO purpose. So Kashish has done the audit and Kashish has signed the financial statement, and now Garvit had submitted that financial statement with the Security Act 1933 for the IPO purpose. And now let's say Kushagra and Sandeep has buy the share of Garvit company. And later on, they come to know the financial statement which is being provided by the Garvit and signed by the Kashish has some misleading information, has some fraud information, has some overstatement of assets or understatement of liability. Right? In that case of scenario, Kush and Sandeep has a right to sue Kashish directly in addition to Garvit. So they can sue to Garvit, they can also sue to the Kashish also for providing wrong information. Make sense?
Yes.
And they do not have burden to prove that why they are suing Kashish, why they are feeling like Kashish is guilty. So burden of proof is with CPA.
Then what are the after effects of it? Like for an
after effects will be it goes in litigation. then like you will get the notice from AICPA, you will get the notice from the court, you will get the notice from SEC, and then you need to prove that whatever the financial statement you have signed, to the best of your knowledge, you provide all the due care, and you have done audit as per the respective auditing standard requirement. And if the court or SEC or AICPA found that you have done the due care and you have done everything as required by the auditor and respective auditing standard, then you should be fine. But if you have done the negligence, then you will get the huge penalty.
Okay, got it.
And imprisonment as well.
In some cases.
Yes, when it is proved that you have acted negligently,
Mhm.
when it is proved that you have done due care and you have applied all the required auditing standard, then you will not get any issue. But if it is proved that you have not acted diligently and you have acted negligently, or you have ignorant of certain fact, then there will be a huge penalty and imprisonment as well. Right? Here the burden of proof that financial statements are wrong or not wrong is not on investor. It's on CPA and it's on firm, company who is offering IPO. Right? That is important section here. For investor, there's no burden of proof.
Got
Next
it.
is CPA liability for burden of proof and due diligence. So what is the liability of CPA? CPA need to prove that he has not done anything wrong. It's a liability of the CPA that he need to prove that he has taken care of all due diligence, he has taken consideration of all auditing standard requirement, and he is not guilty. So proof or burden of proof is on CPA, not on investor. But there are certain defense available to the CPA. What are those defense? That financial statement are not misleading. For example, investor think like financial statement are misleading, but actually they are not misleading. Right? For example, you have given any disclosure in the financial statement and investor has not read the disclosure. Right? For example, contingent liability. So company has given the disclosure for the contingent liability, and later on that contingent liability hold true and company need to pay for that liability. In that case of scenario, auditor can say that we have given the appropriate disclosure. The financial statement are not misleading. At that point of time, situation was not clear. So we have given in disclosure. We do not know like how much would be the actual liability. Right? In that case of scenario, you will not consider as guilty. Second is the misstatement is immaterial. So if it is like small nut amount, which is less than your materiality, then also it will not impact CPA. Third is plaintiff will not rely on the registration statement and has prior knowledge. So for example, plaintiff has not gone through the financial statement when he has applied for IPO, when he has buy the share. So he cannot say that I rely on financial statement. If plaintiff has not taken into consideration the financial statement which is signed by the CPA, then he or she cannot sue the CPA. Right? Or plaintiff have already the prior knowledge of the fact, then also he or she cannot sue the CPA. Next is CPA exercise due diligence. So as a CPA, you applied all the auditing standard and due diligence, professional skepticism and professional judgment. Right? And you have all the proof with you and appropriately documented in your audit working paper. Right? In that case of scenario also, you will not be considered as guilty. And damages are not related to CPA services. For example, you have signed the financial statement and there is some misleading information, let's say in management discussion and analysis. So you are not signing MDA. MDA is signed by the company, right? So for that case also, you are not responsible. You are responsible only and only to the financial statement, right? If there is any additional information which goes along with the financial statement, for that you are not responsible, right? And last is statute of limitation has expired. That means like, have you heard about statute of limitation? Any idea what is that?
No, sir.
How? Have you read business law in India in your graduation?
It is familiar that I heard the word, but forgot the meaning, sir. Statute of limitation.
Have you guys studied
Sir, is it,
contract? Mhm.
sir, is it like an individual is only liable for a certain period of time?
Yeah, you're close to that. So statute of limitation says, like, if you need to sue to any person, so there should be a time limit to it, right? For example, like in 2000, let's say in year 2000, somebody has committed a fraud against me and somebody has cheated me, and now in 22, can I file a case against him after 22 years?
No, sir.
The answer is no. So there are certain time limit in which you need to take the actions, in which you need to file the case against the CPA. So that's a 2-year time limit. From the date you come to know the fraud, within 2 years you need to file a case. After that, it will be considered as an expired, right? So that is called statute of limitation. So within 2 years from the date of fraud has investigated, you can file a suit, but after that it is considered as expired as per the limitation of statute. Make sense?
Yes, sir. Understood.
Right? So in 1933, so we have done with 1933, required the first time registration, right? These all information are required to file along with the registration, and there are certain companies which are exempt, which are kind of small companies, right? And this is important section 11A from Security Act 33, which is being required for your CPA examination.